I'm delighted to participate in this conference. Indeed, I have the best of memories of having been present at the founding conference over 50 years ago and having been engaged with the IJL ever since. We meet at an important historical inflection moment, not only on the occasion of a global COVID pandemic, but a global political pandemic characterized by a resurgent global authoritarianism, the backsliding of democracies, the assault on human rights, and political prisoners as a looking glass, the whole underpinned by yet another pandemic, the pandemic of impunity. Accordingly, I would like to share with you 4 case studies of this political pandemic and the pandemic of impunity and the human rights advocacy that can address and redress it, that can help secure justice for the victims and accountability for the human rights violators, and where the IJL can also play an important role in this effort. The first case study is that of Xi Jinping's China, and I use that term to distinguish it from the people of China who are otherwise the targets of Xi Jinping's massive domestic oppression, which represents today the most serious assault on the rules-based international legal order, and which includes the targeting and increasingly under the cover of the pandemic, the targeting of what Xi Jinping has called the 5 poisons, the mass atrocities against the Uyghurs, the political persecution and prosecution of the Falun Gong, the assaults not only on the democracy movement in Hong Kong, but on democracy itself, the repression of Tibetans and the threatening of the Taiwanese. And there is more. What is not so well known is that China jails more journalists than any other country in the world, jails lawyers and human rights defenders. And it was this suppression of information, this jailing of dissidents and doctors, of lawyers and human rights defenders, which precipitated the spread of the coronavirus, and also the increasing global disinformation campaign and penetration campaign, which the Canadian National Intelligence Parliamentary Committee said constituted a threat not only to the national security of Canada in terms of Xi Jinping's penetration into Canada, but indeed a threat to our democracy. But it is the mass atrocity against the Uyghurs, acts that the Foreign Affairs Committee of the Canadian Parliament said recently were acts constitutive of genocide, that represents the most serious and threatening assault on the rules-based international order. I testified before the Canadian Foreign Affairs Committee this past July, wherein I myself brought forth evidence that the mass atrocities were acts constitutive of genocide. But just before I was to testify, I witnessed evocative and chilling images of Uyghurs blindfolded, heads shaven, shackled, boarded on trains to the concentration camps. I make no analogies to the Holocaust, not even in the acts constitutive of genocide. But one could not ignore these evocative, chilling images. And I then shared with the Foreign Affairs Subcommittee the evidence that these mass atrocities were acts constitutive of genocide, which included the mass incarceration of over 1 million Uyghurs in concentration camps, enslaved, tortured, abused, raped, and murdered. the mass sterilization of Uyghur women as one of many coercive population control techniques that have drastically reduced the population of the Uyghurs. The forced separation of Uyghur children from their families. The massive assaults on the Uyghur religion, culture, identity, language, and which has included also the destruction of thousands of mosques and state-sanctioned incitement to hate and genocide at the Uyghurs, characterizing them as a cancer and worse. All of this, as I said, not only constitutive of acts of genocide, but which recalled for me and which were in my mind's eye as I spoke, the warnings of Nobel Peace Laureate and Holocaust survivor Elie Wiesel, who warned us of the danger of silence in the face of evil, of the danger of indifference and inaction in the face of mass atrocity and genocide. Where, as he put it, indifference always means coming down on the side of the victimizer, never on the side of the victim. And as we have witnessed that the Holocaust and the genocide that follows not only have been engaged in unspeakable horrors, but what makes these horrors so unspeakable is that they were preventable. Nobody can say, for example, with regard to the genocide of the Tutsis in Rwanda, where 10,000 Tutsis were murdered every day for 3 months. Nobody could say we did not know. We knew, but we did not act. Just as with regard to the genocide in Darfur, we knew, but we did not act. And now with regard to the Uyghurs, we now know, and we are still not acting. The second case study is Khamenei's Iran. 2 years ago, the Raoul Wallenberg Center for Human Rights, which I chair, produced a report called Realizing Rights Over Repression in Iran, documenting and detailing the assault by the Iranian regime on the leaders of all civil society groups in Iran. Assaults on women, on journalists, on environmentalists, on lawyers, on trade unionists, on religious and ethnic minorities, on students, on peace protesters, on dual nationals, and the like, reflecting, in effect, a widespread and systematic assault and amounting to the criminalization of innocence, the criminalization of fundamental freedoms. Nasrin Sotoudeh, who you saw on the video, is the iconic Iranian woman human rights lawyer who embodies the struggle for human rights in Iran and whose persecution and prosecution is a looking glass into the assault on human rights in Iran. Nasrin Sotoudeh has gone down the line ever since and before and since her first imprisonment 10 years ago. And I've been acting as her international legal counsel for the last 10 years, where she has been repeatedly arrested for doing nothing other than going down the line for the rights of women, for the rights of juveniles destined for execution, for the rights of journalists whose expression is silenced, for the rights of minorities like the Baha'i targeted for persecution, for lawyers imprisoned for defending political prisoners, and on behalf of other political prisoners, until she became, some 2.5 years ago, yet again a political prisoner herself, and sentenced just a little over 2 years ago to 38 years in prison and 148 lashes, a virtual death sentence for a woman in her late 50s. In August, some 3.5 months ago, she launched a hunger strike not on her own behalf, but on behalf of other political prisoners at risk of catching COVID in the Iranian prisons. Suffering from heart complications and respiratory disease, she was transferred from Evian prison to the hospital for medical treatment. But she was denied the treatment at the hospital, abused and detained at the hospital, and returned to prison, a decision that the UN special experts collectively called unfathomable. While in Evian prison, while engaging in our advocacy, we enjoyed the support of Prime Minister Trudeau of Canada, who condemned her imprisonment and called for her release, as did President Macron of France, as did then President and presidential candidate Joseph Biden, now President-elect, as did the European Union. But she was transferred not only from Evian prison to medical treatment, which they assured her she would then get, but to another prison, Korchak prison, which is characterized as the end of the world, being a vermin-infested prison. Resulting from sustained advocacy, a month ago, she was released on furlough, but just 2 days ago, returned again to prison. And so we conveyed an open letter to the Iranian leadership, a letter signed by the International Bar Association, by USA PEN, by the Center for Human Rights in Iran, and by the Raoul Wallenberg Center for Human Rights in Canada, which I chair, calling not only for the quashing of her conviction and her release, but saying that every day of her continuing imprisonment is an assault on the Iranian Islamic Constitution, on Iran's international treaty obligations, and that only her release would demonstrate Iranian fidelity to the rule of law, to her own law, and to Iran's own international treaty obligations. The third case study is Maduro's Venezuela. Some 4 years ago, I was appointed as a member of a panel of independent legal experts, as it was characterized by the Organization of American States, to look into whether there are reasonable grounds to believe that crimes against humanity are being committed in Venezuela. In May 2018, after comprehensive inquiry, after analyzing all the documentary evidence and witness testimony, we concluded that there are reasonable grounds to believe that 7 major crimes against humanity were being committed in Venezuela, including multiple murders and extrajudicial executions, some 12,000 cases of arbitrary detention and deprivation of liberty, some of the worst evidence of torture that we have ever seen, disappearances, political persecutions, sexual violence and rape in detention and without, and perhaps the worst of the crimes against humanity, state-orchestrated humanitarian suffering, the weaponization of food and medicine, targeting their withdrawal from those in the opposition or those believed to be in the opposition. In the course of our investigation, we held public hearings in Washington, and the evidence with respect to the assaults on the rule of law and the independence of the judiciary and the democratic opposition was astounding. Let me just give you one case study. I had been representing the leader of the Democratic opposition, Leopoldo Lopez, who had been imprisoned himself on trumped-up charges. But what we heard in the testimony before us was both compelling, revealing, and in fact indicting of the Maduro regime expressly and specifically. We heard from Judge Renata Tovar, who had escaped from Venezuela, who appeared before our hearings in Washington and testified that she was ordered to issue a false arrest warrant against Leopoldo Lopez, lest she end up with what was characterized to her by the Maduro regime as the Afuni effect, referring to the imprisonment and torture of Venezuelan judge Maria Lourdes Afuni for doing nothing other than acquitting a political prisoner, as a result of which she, Judge Afuni, 10 years ago, was arrested, imprisoned, tortured, in detention, and has been languishing ever since. And indeed, recently was convicted to yet another 5 years under the false and invented charge of spiritual corruption. I've also been acting on behalf of Judge Afuni because the Afuni effect is used and has been used to intimidate other judges, as I mentioned, with regard to Judge Renata Tovar. We also heard from the special prosecutor in Lopez's case, Franklin Neves, who also had escaped from Venezuela, who came before our inquiry and testified that he was ordered to issue false and trumped up charges against Leopoldo Lopez. And we heard from witnesses who said that they were tortured into false confessions against Leopoldo Lopez. The whole demonstrating the massive assault on the rule of law, the independence of the judiciary, and the democratic opposition in Venezuela. 6 months after we tendered our report, the Foreign Minister of Canada at the time, Chrystia Freeland, led 7 nations in making the first ever collective referral of a state party to the ICC, namely Venezuela, to the International Criminal Court. But to date, Venezuela has yet to open an investigation into the crimes against humanity in Venezuela, notwithstanding the fact that the UN Commission on Human Rights issued its own fact-finding report 6 months ago that corroborated our report, Crimes Against Humanity in Venezuela. And just days ago, the Organization of American States, through its newly appointed special rapporteur on the responsibility to protect, Jared Genzer, also a senior fellow at our Raoul Wallenberg Center for Human Rights, issued a report that not only corroborated our OAS report and the UN Commission on Human Rights report of crimes against humanity in Venezuela, but in fact unmasked the special prosecutors in action in not opening an investigation. The whole to be contrasted, and you just heard from Roy Schondorf, with the case of the ICC opening up an investigation into the special prosecutor, into the situation in Palestine, even though Israel, unlike Venezuela, is not a state party to the ICC, even though Palestine is not yet a state and does not even constitute the attributes yet, though I've supported Palestinian self-determination and right to independent statehood, but is not yet a state and does not yet have the attributes for statehood under international law. And where other principles of complementarity and the gravity of the offense, and those discussed so eminently by Roy Schondorf, should preclude any jurisdiction by the ICC in this case. So the ICC does not take jurisdiction in a case where the evidence is so compelling of crimes against humanity as in Venezuela, and does not open an investigation there, but does do so in the case of the situation of Palestine with regard to Israel, which in effect impugns, for the reasons I mentioned, the independence, impartiality, and integrity of the ICC. And I say this not only as someone who's been a long-time supporter of the ICC, but who, as a parliamentarian, convened the first ever Parliamentary Consultative Assembly for an International Criminal Court in 2002, who tabled legislation adopted by the Canadian Parliament domesticating the Rome Statute in Canadian legislation and authorizing a universal jurisdiction, who's been supportive of the ICC as a successor international tribunal of final adjudication to Nuremberg, not a tribunal of original jurisdiction, let that be clear, but who has been consistently disappointed of late in what appears to be dual standards as exemplified in the Venezuelan and situation of Palestine assumption or non-assumption of jurisdiction by the court. The fourth and final case study is that of Mohammed bin Salman's Saudi Arabia. And is
Professor
the
Cotler,
case
if you could
of the imprisoned Saudi blogger Raif Badawi. Badawi was imprisoned 8 years ago for saying then what the Crown Prince Mohammed bin Salman has been saying himself for the last 3 years, namely calling for a more open Saudi Arabia, a more moderate Islam. But not only has he been imprisoned and is now in his 8th year of imprisonment, as you saw in the video, but so has his sister Samar Badawi for doing nothing other than calling for the right to drive, a reform that in fact was implemented by the Crown Prince himself. 2.5 years ago, the then Foreign Minister Chrystia Freeland tweeted a call for the release of the two Badawis. The Saudi authorities erupted in fury, ejecting the Canadian ambassador from Saudi Arabia, recalling the Saudi ambassador to Canada, suspending all trade and investment with Canada, recalling 15,000 Saudi students from Canada, in effect a self-inflicted wound. But the reason I'm sharing this with you is that not one democracy came to Canada's defense. And 2 months later, Mohammed bin Salman, feeling enabled, this took us down the road to the brutal assassination of Saudi journalist Jamal Khashoggi in the consulate in Istanbul. That brutal assassination, for a period, did sound the alarm. And there was the mobilization of concern with respect to what is happening in Saudi Arabia. But that soon abated, and we saw, as part of the culture of impunity, Saudi Arabia being rewarded with being chair of the G20, which held its meetings just weeks ago, where no mention was made of either the imprisoned women human rights defenders, nor of the case and cause of Raif Badawi. And I would like to think that maybe Israel has a role that it can play here in that, given the recent meetings between Netanyahu and MBS, given the fact that President-elect Biden has said that there will be a change in U.S. policy towards Saudi Arabia in terms of accountability and the like, Israel, through quiet diplomacy, might recommend to MBS that it would be in his self-interest, in the interest of Saudi Arabia's relationships with the incoming Biden administration, to free the 5 imprisoned women human rights defenders and to free Raif Badawi, and that this quiet diplomacy by Israel could someday also inure to Israel's benefit. In conclusion, I believe that the
and then we'll move to the questions. Yeah.
Lawyers and jurists has a role to play in combating the global political pandemic and the pandemic of impunity. One, unmasking and exposing the culture of criminality and corruption and the impunity that has underpinned it. As Andrei Sakharov used to say, the mobilization of shame against the human rights violators. Second, by taking up the case and cause of the Uyghurs, the worst human rights assault in contemporary times, taking up the case and cause of a situation where we are witnessing at this point acts constitutive of genocide. Third, taking up the case and cause of Nasrin Sotoudeh, who, as I said, is the embodiment of the struggle for human rights in Iran. And indeed, while Israel has spoken often of the Iranian fourfold threat, the nuclear, the terrorist, the regional hegemonic, the incitement, it has not spoken sufficiently of the assault on human rights in Iran. I appreciate that Iran's enmity towards Israel may not necessarily, in fact, invite any positive reaction from the Iranian regime should Israel speak up on behalf of Nasrin Sotoudeh, looking glass into the assault on human rights in Iran. But in engaging with that, it can help to unmask and expose the assault by Iran on its own law and its own treaty obligations. The IJL could also take up the case of the imprisoned Venezuelan judge, Maria Lourdes Afiuni, whom I mentioned, and finally to take up the case and cause of Raif Badawi and the imprisoned human rights defenders. Finally, I would be remiss if I did not mention very briefly two other concerns. One is the repatriation of the bodies of the fallen soldiers, Hadar Golden and Oren Shaul, and the two missing civilians, whose lack of repatriation of the bodies and whose detention of the civilians constitute a standing assault on foundational principles of international human rights law regarding the right to information, the right to truth, the right to repatriation of the fallen soldiers, and the right to accountability. And the international community, as trustees of international human rights law, has to be called to account on this and not be a bystander community to these violations. The second, and it was mentioned so compellingly and so brilliantly by Ilan Carr that I will not repeat anything other than to just reaffirm all his lessons, but only call for one thing, that Israel should appoint a special envoy respecting combating anti-Semitism so that it could become part of the community of nations that have themselves designated special envoys. In conclusion, we must see it as our individual and collective responsibility, distinguishably so as the IJL, to speak on behalf of those who cannot be heard, to bear witness on behalf of those who cannot testify, to act on behalf of those who are putting not only their lives, not only their livelihood, but their lives on the line. This is what the pursuit of justice is all about. This is what tzedek tirdof is all about, and this is the mandate and mission so compellingly implemented by the IJL. Thank you.
Thank you very much. That was fascinating. And by the way, in the chat, it is written. That is great. This is fascinating. I couldn't stop you because it was so interesting. So, a few questions. The one with regard to the ego wars. So, someone was wondering, why don't Muslim countries protest more to China about the persecution of their own co-religionists? Because these are Muslims. Another question with regard to the ICC is, do you have connections? How can one impact the ICC in the directions that you mentioned? And another question is, can you describe how the anti-Semitism that we see today is also part of the pandemic of impunity? Isn't the demonization and growing exclusion of Jews, particularly Jews who express pride in their Jewish national and ethnic heritage, a form of national and ethnic origin discrimination and a human rights violation? And another question with regard to the two soldiers, the deceased soldiers, Goldwasser and Hadar Goldwin, what efforts are being done in the international arena? So a bunch of questions. We only have 4 minutes. The floor is yours again.
Thank you, Pinion. I'll try to be brief. With regard to why other Muslim countries are not standing up and supporting the Muslim Uyghurs, regrettably, there has been, as I say, not only a pandemic of impunity, but Xi Jinping's China has managed really to bully countries individually as a result of their economic leverage and political leverage and the like. And this has resulted not only with regard to Muslims not standing up, but other members of the international community themselves not asserting this case and cause. 6 months ago, we formed the first ever interparliamentary alliance on China. I'm one of the co-chairs from Canada, the hope being to begin to reverse this asymmetrical power relationship. One of the first cases and causes that we've taken up has been that of the mass atrocities against the Uyghurs. And gradually we're beginning to see Muslim voices also being engaged. Recently, I was part of a webinar that was co-sponsored by the Jewish law students and the Muslim law students at Harvard Law School. And this is one snapshot of increasing Jewish and Muslim groups working together in common cause with regard to the Uyghurs. And here I invite, as I say, the IJL to lend its own supporting and effective advocacy in this regard. In the matter of the ICC, I was one of a number of 6 international lawyers that did file an amicus brief before the ICC, whose main argument effectively was that the ICC simply did not have jurisdiction in this case. And I think and I know that the IJL also intervened in the case. I think it's important that the issue be not one of support for Israel or not, but that what is at issue here is the integrity, the independence, the impartiality of the ICC. And that is why I used Venezuela as a looking glass into the double standards here. And therefore, those who care about the ICC as being a successor court of final jurisdiction to Nuremberg, we're now meeting on the 75th anniversary of the Nuremberg trials, we need to return to that notion of independence and integrity and impartiality of international tribunals and all those associated with it. And the ICC at this point must live up to its mandate and not be appearing to, in fact, abusing that mandate. In the matter of anti-Semitism and the denunciation of Israel, there is a global pandemic with respect to anti-Semitism, a resurgent global anti-Semitism that targets both traditional anti-Semitism and the new anti-Semitism. By traditional anti-Semitism, I speak of the rights of Jews to live as equal members in any society which they inhabit, and that the assault upon and denial of those rights constitutes discrimination against Jews in any community which they inhabit. But the second and sometimes ignored dimension is the discrimination, assault upon, and denial of the right of the Jewish people to live as an equal member of the family of nations. This is the new anti-Semitism. There's no difference between the old and the new in the sense that both share the foundational principle of discrimination against Jews, where the discrimination against Jews as individuals has passed to discrimination against Jews as a people, and Israel emerges as the targeted collective Jew among the nations. And those of us who support the principle of equality, the principle of international human rights, the principle of anti-discrimination, the principle of the right of indigenous peoples to self-determination, must speak up and call out the old and new anti-Semitism, which is anchored in the worst of discrimination, which takes us down the road, as we know, to mass atrocity.
Thank you.
And finally,
thank you, Professor Cotler. I'm sorry, we will have to wait for another opportunity to hear the answer for the first question, because we are out of time, and this was fascinating. Thank you so much for this presentation and for all the work you are doing, and good luck and success in your new position. Your success is our success. It's good for all of us, and we hope that you manage to help also in combating anti-Semitism, Holocaust denial, and continue your good work in promoting human rights around the world. Thank you so much.
Thank you, Pnina, and kol kavod.